Legal risk areas. Several differences distinguish unintentional torts from intentional torts. Unintentional torts, for example, professional negligence, do not require intent but do require the element of harm. In contrast, with intentional torts, the defendant executed the act on purpose or with intent. No harm need be caused by intentional torts for liability to exist. Also, since no standard is involved, no expert witnesses are needed. 4 intentional torts related to nursing are discussed here: assault/battery, false imprisonment, invasion of privacy, and defamation, libel/slander. Assault. Assault occurs when a person puts another person in fear of a harmful or offensive contact. The victim fears and believes that harm will result because of the threat. Assault can be described as an attempt or threat to touch another person unjustifiably. Assault precedes battery. It is the act that causes the person to believe a battery is about to occur. For example, the person who threatens someone by making a menacing gesture with a club or a closed fist is guilty of assault. A nurse who threatens a client with an injection after the client refuses to take the medication orally would be committing assault. Battery. Battery is an intentional touching of another's body without the other's consent. Battery is the willful touching of a person, or the person's clothes, or even something the person is carrying, that may or may not cause harm. To be actionable at law, however, the touching must be wrong in some way, for example, touching done without permission, that is embarrassing, or that causes injury. In the previous example, if the nurse followed through on the threat and gave the injection without the client's consent, the nurse would be committing battery. Liability applies even though the primary care provider ordered the medication or the activity, and even if the client benefits from the nurse's action. Consent is required before procedures are performed. Battery exists when there is no consent, even if the plaintiff was not asked for consent. Unless there is implied consent, such as in life-threatening emergencies, a procedure performed on an unconscious client without informed consent is battery. Another requirement for consent is that the client be competent to give consent. It can be very difficult to determine if clients who are older, who have specific mental disorders, or who take particular medications are competent to agree to treatments. If the nurse is uncertain whether a client refusing a treatment is competent, the supervisor and primary care provider should be consulted so that ethical treatment that does not constitute battery can be provided. Determination of competency is not a medical decision, it is one made through court hearings. Invasion of privacy. Invasion of privacy includes violating confidentiality, intruding on private client or family matters, and sharing client information with unauthorized persons. Invasion of privacy is a direct wrong of a personal nature. It injures the feelings of the person and does not take into account the effect of revealed information on the reputation of the person in the community. The right to privacy is the right of individuals to withhold themselves and their lives from public scrutiny. It can also be described as the right to be left alone. Liability can result if the nurse breaches confidentiality by passing along confidential client information to others or intrudes into the client's private domain. In this context, a delicate balance must be maintained between the need of a number of people to contribute to the diagnosis and treatment of a client and the client's right to confidentiality. In most situations, necessary discussion about a client's medical condition is considered appropriate, but unnecessary discussions and gossip are considered breaches of confidentiality. Necessary discussion involves only those people engaged in the client's care. Clinical alert. Never discuss client situations in the elevator, cafeteria, or other public areas. Most jurisdictions of the country have a variety of statutes that impose a duty to report certain confidential client information. 4 major categories are: A. Vital statistics, such as births and deaths. B. Infections and communicable diseases, such as diphtheria, syphilis, and typhoid fever. C. Child or abuse of older adults. And D. Violent incidents, such as gunshot wounds and knife wounds. The client must be protected from 4 types of invasion. First, use of the client's name or likeness for profit, without consent. This refers to use of identifiable photographs or names such as advertising for the healthcare agency or provider without the client's permission. Second, unreasonable intrusion. This involves observation of client care, such as by nursing students, or taking of photographs for any purpose without the client's consent. Third, public disclosure of private facts. This occurs when private information is given to others who have no legitimate need for that information. And fourth, putting a person in a false light. This type of invasion involves publishing information that is normally considered offensive but which is not true. False imprisonment. False imprisonment occurs when a client is not allowed to leave a healthcare facility when there is no legal justification to detain the client. False imprisonment occurs when restraining devices are used without an appropriate clinical need. A client can sign an against medical advice form when the client refuses care and is competent to make decisions. The nurse should document circumstances in the medical record to avoid allegations by the client that cannot be defended. False imprisonment is the unjustifiable detention of a person without legal warrant to confine the person. False imprisonment accompanied by forceful restraint or threat of restraint is battery. Although nurses may suggest under certain circumstances that a client remain in the hospital room or in bed, the client must not be detained against the client's will. The client has a right to insist on leaving even though it may be detrimental to health. In this instance, the client can leave by signing an AWA, absence without authority, or AMA, against medical advice, form. As with assault or battery, client competency is a factor in determining whether there is a case of false imprisonment or a situation of protecting a client from injury. To guide nurses in such dilemmas, agencies usually have clear policies regarding the application of restraints. Unjustified retention or prevention of the movement of another person without proper consent can constitute false imprisonment. For example, only a reasonable amount of restraint should be used in circumstances that warrant it. The indiscriminate and thoughtless use of restraints on a patient can constitute false imprisonment. A person cannot be legally forced to remain in a health agency, such as a hospital, if he or she is of sound mind, even when health practitioners believe the person should remain for additional care. Health agencies have special forms to use when a patient insists on being discharged against medical orders. The patient signs to indicate that he or she does not hold the agency responsible for any harm that may result from leaving. People who are mentally ill may be committed to a psychiatric institution for treatment without their consent, involuntary commitment, only when it can be proved that they may be harmful to themselves or others. Defamation. Defamation is a false communication that causes damage to someone's reputation, either in writing, libel, or verbally, slander. Defamation is communication that is false, or made with a careless disregard for the truth, and results in injury to the reputation of a person. Both libel and slander are wrongful actions that come under the heading of defamation. Libel is defamation by means of print, writing, or pictures. Writing in the nurse's notes that a primary care provider is incompetent because he did not respond immediately to a call is an example of libel. Slander is defamation by the spoken word, stating unprivileged, not legally protected, or false words by which a reputation is damaged. An example of slander would be for the nurse to tell a client that another nurse is incompetent. Only the person defamed may bring the lawsuit. The defamatory material must be communicated to a third party such that the person's reputation may be harmed. For example, a comment made in private criticizing that person's competence is not defamation since a third party did not hear it. Nurses have a qualified privilege to make statements that could be considered defamatory, but only as a part of nursing practice and only to a primary care provider or another health team member caring directly for the client. The communication must be made in good faith with the intent to protect the quality of client care. For example, when a nurse manager provides a prospective employer with information about a nurse's professional practice. Fraud. Fraud results from a deliberate deception intended to produce unlawful gains. Fraud is willful and purposeful misrepresentation that could cause, or has caused, loss or harm to a person or property. Misrepresentation of a product is a common fraudulent act. A person fraudulently misrepresenting himself or herself to obtain a license to practice nursing may be prosecuted under the state's Nurse Practice Act. Also, misrepresenting the outcome of a procedure or treatment may constitute fraud.